Good morning, everyone. I'd like to call this meeting of the Property Standards Committee to order at 9:30 a.m. on October 8th, 2005. My name is Nicholas DeBono. I'm the City Clerk for the City of Thorold. I'll be assisting with the administration of this hearing. As this is the first meeting of the Property Standards Committee during this term of council, we'll begin by appointing a chair to preside over today's proceedings. Until that time, I will guide us through some initial steps. This hearing is being held to consider an appeal of a property standards order issued under the authority of the municipality's Property Standards Bylaw and the Ontario Building Code Act. This is a quasi-judicial hearing, which means the committee is acting in a decision-making role and will hear evidence from both bylaw enforcement staff and the appellant before making a decision. Members of the public are welcome to observe, but only the parties to the appeal and the committee members are parties to the hearing. The committee may ask questions of both the bylaw staff and the appellant after their respective presentations before proceeding to deliberation and a decision. Just remind that everyone is expected to remain respectful and preserve decorum in the council chamber. That's a given. Individuals who are addressing the committee are to provide their name, but otherwise we request that when giving evidence that personal information, including address and contact information of third parties, be preserved as much as possible. We'll now proceed to the next item on the agenda, which is the appointment of the chair for the Property Standards Committee. At this time, I'll ask if any committee members wish to nominate anyone to act as chair. Yes, Mr. Pizzo, if you just wanted to put your mic on when you... Mr. Pizzo?
I nominate John.
Okay.
I always pronounce your name wrong, you know that.
That's okay. Okay, Mr. Thiessen, do you accept the nomination?
Tyson, yes.
Tyson, sorry. Okay. So at this point, does anyone wish to nominate anyone else, or? Okay. So seeing no other nominations, can I have a mover and a seconder to appoint John Tyson as chair for the Property Standards Committee? I have a mover in Mr. Jackson, a seconder in Mr. Ravenik. Okay, all those in favor, please raise your hand. Okay, no one's opposed, so that carries. So Mr. Tyson, you can now assume the role of chair if you wanted to head up to the lectern there.
All right. Thank you to Mr. Pizzo and the others. Now we move forward to the land acknowledgement. Mr. Clerk, please. Not yet.
Through you, Mr. Chair, the City of Thorold is situated on treaty land. This land is steeped in the rich history of the First Nations, such as the Haudenosaunee, the Haudenosaunee, and the Anishinaabe, including the Mississaugas of the Credit First Nation. There are many First Nations, Métis, and Inuit people from across Turtle Island that live and work in Niagara today. The City of Thorold stands with all Indigenous people, past and present, in promoting the wise stewardship of the lands on which we live.
Thank you, Clerk. Do we have any declarations of conflict of interest? Seeing none, nor do I. Can we have a mover and a seconder to adopt the agenda as presented? Moved by Mr. Ravenik, seconded by Mr. DePaul.
Sorry, Mr. Chair, there will just be a slight amendment to the agenda. I decided to make just a few comments after the appointment of the secretary, just so everyone's aware, if that's okay.
Mover and seconder okay with that? Friendly amendment, thank you. All in favor of the motion? Thank you. Now we need a mover and a seconder for the appointment of the secretary. Is there a seconder for that? Mr. Jackson?
No,
wait,
sorry,
maybe-
the secretary, through you, Mr. Chair, is not to be a member of the committee. We do have a secretary treasurer for the Committee of Adjustment, Ms. Courtney Kopp, who's sitting right there next to you, so.
Well, why didn't you say something before, you know?
That's okay. That's okay. We have a further nomination for secretary treasurer.
Yeah, I nominate Courtney for
Mr.
that
Ravenek?
position.
Thank you. Do we have a seconder for that? Mr. DiPaolo? I think we'll vote on that motion if you don't mind. All in favor? Thank you. Welcome, Courtney. You can flip your tag over there now. Nicholas, you have some comments here, or are these part of the comments you made beforehand?
Okay, thank you, Mr. Chair. Through you, so before we begin this hearing, I'd just like to provide the committee and those present watching with a brief overview of the process we'll follow, along with an overview of the committee's authority under the Ontario Building Code Act, specifically Section 15.3, Sub 3.1. Before the committee today is a single matter, which is an appeal of an order issued under the city's property standards bylaw. Committee was provided with information from Bylaw Enforcement Division, and the appellant has prepared and provided information for the committee that was included in the agenda package, and I understand there was some additional information provided just now. City bylaw staff is here to provide their information on the matter. They'll be sworn in by the secretary, Ms. Kopp, before giving evidence. Once bylaw staff have provided their evidence, the appellant is able to ask questions. Then the committee may ask questions of bylaw staff. The next stage is then the appellant is able to provide their evidence. As with city staff, the secretary will swear the appellant in. The appellant may then provide their evidence or testimony. City staff is able to ask questions, and then so can the committee. After hearing the evidence from both bylaw staff and the appellant and following any discussion, the committee may make one of three decisions. They can uphold the order, meaning the order issued by the bylaw enforcement staff stands as written. They can modify the order. The committee may alter the terms of the order, such as extending the time for compliance or adjusting certain requirements in the order. The third option is the order can be rescinded by committee decision if the committee feels that the evidence doesn't support it being issued. Please note that the committee's decision must be based solely on the evidence presented during the hearing. Following the committee's decision, a written notice will be sent to the appellant. If the appellant or municipality is not satisfied with the committee's decision, it may be appealed to the Superior Court of Justice under Section 15.3, Sub 4 of the Building Code Act. Committee members are reminded that, of course, you can ask questions before proceeding to discussion and a decision. So, Mr. Chair, we may now proceed to the hearing of the appeal.
Thank you to the clerk. We'll now begin the process. First presentation will be from the bylaw enforcement staff. May I have the secretary of the committee affirm the witness?
Shelby? Yes, hi. Do you solemnly affirm that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you.
Bylaw staff, you may begin when ready.
Hello, my name is Shelby. I'm a bylaw officer with the City of Thorold. I received a complaint from the tenant at Unit 103 at 2 Water Street for mold issues, as well as her floor is in disrepair. On July 3rd at 1 p.m., I attended the property with my coworker Jacob Bellows to do an inspection of Unit 103. While I was on my inspection, I observed in multiple areas what appeared to be mold in the windowsills as well as the bedrooms, on both the baseboards and in the corner top parts of the bedroom. The windowsills, yes.
No, through you, Mr. Chair, that's, no, she's not reading off that. Yes, a summary of the evidence that was provided. Yeah.
I'm not too sure what.
That was a script for the chair that I had prepared, so that, no, she's not following that.
Okay. I observed what appeared to be mold, as well as during my inspection, I did a thorough inspection of the entire unit, and throughout the main level, the main part of the unit in the living room and kitchen area, the floors were in extreme disrepair, lifting up from the floor. Pieces were missing as well. The tenant has had to put duct tape down on the floor to try to keep the flooring from slivering her feet, her children's feet, and her elderly parents' feet, as well as she had carpets over multiple spots in the floor to just try to keep it safe for everybody. As well as it was observed that there was parts of her wall that were in disrepair that she attempted to fix on her own because she stated that she could not get somebody in to fix them for her. As a result of my inspection, we did issue a property standards order to the owner for a mold technician to come in and verify if my findings were mold, and based on their inspection, the remediation process for that the landlord was to follow, as well as the floor throughout Unit 103 was found to be uneven with protruding particles. So it was requested of the landlord to repair and fix the floors for the tenant, as well as the walls. We requested that the owner repair any deficiencies in the walls that were in disrepair. Is there any questions regarding my findings?
Go ahead, Mr. Pizzo.
The day I inspected it was July 3rd.
So Shelby, just to be clear, you haven't been back to the unit since July 3rd.
No.
Mr. Ravenek?
So just to be clear here, you had requested that the owner have a mold inspection completed by a certified technician, and if it's my understanding, one was never submitted to you or the city?
One was never submitted to the city. No.
Thank you.
Mr. DiPaolo?
Through you, Chair, and just to make sure so anything I ask is just for my understanding here. You went on July, but clearly the matter started significantly before July, correct?
Yes, there was email back and forth between the tenant and my manager, Danny Vukovic.
Yeah. When you went there, I'm just trying to make sure I understand everything. You went specifically to look for the mold. Is that why you went?
Yes, the tenant had said that there was mold that kept coming back into her unit.
Perfect.
That wasn't getting.
Perfect. Thank you. Secondly, why, I'm just curious why, once you investigated the mold, was it a safety issue that you continued to investigate beyond the mold? And you found, like you brought up floors and you brought up walls, but the tenant seemed to call you only for the mold. So why did the investigation, the scope of your investigation, go beyond that?
When we do an inspection of any property, it's our due diligence to do the entire unit, finding any deficiencies that might come up during that time.
Okay. And that's what I was trying to understand, if it was just perfect. And thank you.
Mr. Pizzo?
Again, when we do an inspection, we do the entire unit. The tenant.
Mr. Ravenak?
Okay, just for clarity, can you, we were given a package, I don't know whether we can reference, but there were pictures included in the package. And I'm curious if you can describe, or whether the pictures can be put on the screen so that they can become part of evidence, where particularly in the unit the mold was.
Shelby, while the clerk is putting that up, have there been other units in this building that you've been called on?
No other units came forward with issues.
Mr. Ravenak?
Yes, so as the clerk's scrolling through the pictures, if you could just describe where these are to the best of your recollection in the unit, please.
So that is a window, I believe, in the main area that overlooks from the living room, I believe. That is another window that the tenant stated she has been trying to clean the mold multiple times with the paint chipped in the corner due to multiple attempts to remove the mold with bleach.
That mold on the lower part of the window, is that mold? That you're saying?
Yes,
And then
what appears to be.
it's not painted there.
Because she's repetitively cleaning, she stated she's repetitively cleaning that area, causing the paint to chip. Yeah. That is what appears to be mold in the bottom part of the baseboard in one of the bedrooms.
Appears.
Next one.
Oh.
Yes.
Okay, a question relative to the window. Do you recall where that picture is? Like, is the window above
The
it?
same room,
The same room?
I believe so.
Okay.
That's also in the bedroom.
And
Next
just to
row.
clarify, it appears to be a
Appears
picture of
to
the
be.
ceiling?
Yes. There's a more. Pardon?
Mold on the ceiling. You're saying that's mold. It's not a bad plaster job.
What appears to be.
He knows what I'm talking.
Through you, Chair, I just wanted to provide some clarification. Due to the fact that we have children and elderly residing in the unit, we're not experts to determine if something is mold or is not. If it appears to be mold, we are seeking professional opinion to ensure that the occupants are not exposed to any hazards.
That is another window that the tenant stated she repetitively is cleaning to remove the mold as well. Again, note the paint chipping from bleach. Next photo. This was the wall that this tenant stated there was a hole and she attempted to repair it herself because she stated nobody would come repair it for her. And these photos are the flooring, which shows that the tenant has put tape down in multiple areas to keep the floor from lifting, to provide a temporary safe environment for her kids and her parents. And note the carpet as well. She has placed carpets down in the more severe areas to prevent the floors from lifting. Keep going.
Okay, is the mold present in more than one room?
Yes, both bedrooms. She noted mold as well as the windows, which were in the bedrooms as well as the living room area from the kitchen.
Okay, so it's in two bedrooms and the living room?
Yes,
And are these exterior walls?
yes.
Mr. Pizzo?
Chairman, did you have an expert look at the mold? You said you're not an expert on mold. Did anybody look at the,
Yep.
Through you, Chair. No, we did not have an expert. We request an expert to look.
What?
We request, through the property standards order, we request an expert to assess the situation, provide us a report, therefore we can evaluate what their recommendations are. So we're not experts. We can't deem it mold, but if it appears to be mold, before we,
appears to be mold?
if it appears to be, if the substance appears to be a health hazard, we ask for a professional opinion. So an expert will come in, assess the unit, and advise us that this is or it isn't mold. But it does come from an expert remediator, and we take that expert opinion and then follow their direction.
I just don't understand your statement, you're not an expert. Why didn't you bring somebody in that, a mold expert?
Through you, Chair, that is not the responsibility of the municipality. Our responsibility is to request the report from the landlord.
Responsibility is to say it's mold.
Through you, Chair, the expert remediator would have to give us that opinion, and there's an associated cost that comes with that that is passed down to the landlord.
So again, to clarify, you did ask the landlord to provide a written report from a mold expert.
Yes. In the property standards order that was issued, we did request that.
Okay, and to date, that has not, oh, I'm on. And to date, that hasn't been received, again, correct?
No, nothing has been received by the bylaw department, to the bylaw department.
Now, Shelby, just to be clear, this order went out July? This request went out in July?
Yes,
Thank you.
after my inspection.
Thank you. Okay, thank you for now. We'll now let the appellant have his or her time. If you could approach, and is the microphone at the stand there? Thank you to the clerk. Could identify yourself for the record, please.
My name is Emmanuel Junta.
Thank you.
I apologize if my phone rings. I'm on call 24/7. I have a palliative mother at home in her own personal residence. So, to be honest, I don't know where to begin, but I will begin at this point. The tenant moved in May of 23. The management company that was there prior was not a very good communicator. So there was a new management company hired in January of 2024. The management company received complaints constantly of various nature from this tenant, and there were some other complaints in, I think it was April or prior to July, well before July 3rd, there were items that were made known to me that needed to be repaired. For many, many months, the tenant did not report any of these issues. For example, I will refer to the paperwork is on page, it's an email that I sent to Mr. Danny Vukovic. It is on page 10 of the package that I had submitted this morning. This email was sent on May 22nd. I let him know that I've identified and repaired a leaky window brick sill on the exterior of the building on that side. There were all brand new windows installed within a couple months of her moving into the unit. I personally visited the unit and noticed that a window was a bit open. I'm aware that open windows help circulate air. However, there were windows open during any rain. Were there any windows open during rain events? The bathroom fan has been replaced already. The bathroom fan was not working for numerous months before it was replaced. We had no idea that it wasn't working, and we dealt with it once we knew. The contractor who has worked in the unit has notified me of a large amount of animal urine at various points in the unit. This is also verified in the an email sent to me. He was unable to be here, my contractor. It's on page number 13. His English is not very, it's not perfect, but you can see there that he says that he visited the unit and there's a strong smell of urine and pee under the area where the windows are. And as a contractor, he's very, he's busy and needs to be booked ahead of time. Going back to page 10, we've offered her a dehumidifier and to pay for the hydro because she has complained about the potential greater expense of hydro, and she has refused that dehumidifier. She's in a unit that is it's not a basement unit, but if it's half of the unit is below ground and half is above ground. Therefore, the windows are pretty much at ground level. The unit has all new windows. So in a conversation that I had with Mr. Danny Vukovic on prior to June 25th, I let Mr. Vukovic know that I have spoken to the tenant. No longer will there be an intermediary of a management company. And the only reason there is a management company involved is I have to be available 24/7 for my palliative mother. I spoke with the tenant myself. I called her and I said, listen, if you have any concerns whatsoever, please email me directly and I will take care of them. I let Mr. Danny Vukovic know about this concern, and Mr. Vukovic and I spoke about what was left to be fixed in the unit, or to be looked at. There was a small area in the bedroom that the tenant told me was left. There were a couple things that I let her know that in order for me to come in and fix the unit, I have to be able to get into the unit. So I let Mr. Vukovic know that we are going to take care of, I spoke to my cleaning contractor after conversation with a industrial hygienist, which is on there's an email from the industrial hygienist on page 12. His name is David Morrison. I conversed with him in early June. I'm not going to read the email there for exactly, if you wish I can, but it talks about what's been repaired. It talks about what he recommends. I know Shelby mentioned the tenant had cleaned it with bleach or cleaned it with bleach. Bleach is to not be used if it is that. All you need is soap and a microfiber cloth as per the industrial hygienist. So he also recommends to install a dehumidifier in the unit, which she denied. I was willing to provide the dehumidifier, and like I said, I was willing to pay for the any additional hydro. All I asked for was to see some hydro bills before the plugging in of the dehumidifier and hydro bills after, and we would accommodate. The tenant was told that we're going to be cleaning that up by July the 4th. I let Mr. Vukovic know about that, July the 4th. On July 1st, we gave notice that we were going to be coming in to clean. The tenant refused access to the unit. There is actually an N5 on page, in the package I just gave you. An N5, which is on page 5. It's a notice to end your tenancy for interfering with others, damage, or overcrowding. I'm not sure if all of you are aware or not, but a tenant cannot refuse access to the unit. It just doesn't make logical sense to me that someone's going to be complaining about something and not allowing a contractor to come in to address the problem. This occurred on July 2nd. On July 3rd, she called the bylaw department. The bylaw department came in, and to my surprise, this was submitted to me. I was quite appalled at the fact that no one called me to inquire about what was going on, what they saw, what they observed, because when I visited the unit, I let the tenant know that the flooring was in proper condition when she moved in. It's been over 2 years that the tenant has been in the unit. The lease, which I have not submitted to you, but I have here, indicates only 2 tenants for the unit. It was, I only found out when I visited the unit that there were 4 people living in the unit, which is a 2-bedroom apartment, but there is going to be more wear and tear. There's going to be 4 people versus 2 people. I let the tenant know that my contractor will be looking at it. I told the tenant I will be replacing the floor. That's what I told the tenant. And it's going to happen when my contractor is available. And that was going to be most likely at some point in the month of August. Given that she denied access for the cleaning contractor, and my contractor had to book up his schedule, my contractor was not available anymore until October the 6th. The week before October the 6th, I have some emails. You can see, don't have to go through all of them in particular exactly, but she denied access and said that she wants to be home. Technically speaking, if a landlord gives notice and there are issues in the unit, they have the right to come in and take care of those issues. The wall in the unit that was mentioned in the report, when I spoke with Shelby over the phone after numerous attempts to try and converse with the people that submitted the order. I asked Shelby about that, and she said that the tenant later admitted it was her father who fell into the wall and that she repaired it herself. So I had no idea, nor did she report anything about a hole in the wall. In the lease, it does state that any damages caused to the unit by the tenant are the tenant's responsibility to repair. That's where I'm going to leave that issue with the wall. I've offered multiple times. I had the conversation myself with the industrial hygienist as well, and I told my cleaning contractor exactly the specific instructions that need to be used to clean that off. Even the industrial hygienist documents that windows open during rain events is not a good item to have. Again, the tenant has a responsibility to let the landlord know of any issues. The tenant, normal wear and tear items can occur in units after 2 years. By no means have I ever said to the tenant, I'm not going to take care of the floor. But the tenant has denied access and also denied access on October the 6th, hence why we gave the opportunity to the tenant to allow us to come back in, and she denied us again. So that's why the N5 was just recently submitted. And just so the committee is aware, the tenant has not paid rent for September or October. There is bylaw from the landlord, I think the Residential Tenancies Act, you cannot withhold rent for any alleged or potential repairs that need to be done in the unit. I have repaired many items in the unit. The unit was installed, new windows were installed right after the tenant moved in. Normal wear and tear items happen. And it's quite disappointing that I feel that this order was just created and sent. And I've emailed, as you can see, I've emailed the city many times to try and speak with Mr. Jacob Bellows, and after numerous attempts, Shelby did converse with me, and Mr. Vukovic did converse with me as well about the situation. But there is a responsibility on the tenant's part. Things do happen. Things have been repaired. And once the repairs for these alleged mold situations happen, they need to be cleaned, in terms of the words of the industrial hygienist, and then you have to wait and see if it returns or not. So there are a number of factors here that are not very fair to the landlord. By no means, I want to repair anything that's normal wear and tear items and things that get reported, and I have, and there's proof that I have. So it's quite disappointing that the city did not converse with me about this situation, because specifically Mr. Vukovic and I did converse, and it is in an email, that by July 4th, the cleaning contractor was going to be in. So the tenant took it upon herself to deny access on July 2nd, call the bylaw department on July 3rd, and then have this report set up. And in that report, she showed things that were damages caused by the tenant themselves. So I think there's a lot of ill intent here. I think the tenant is not working. She's actually, we conversed, we shared emails. I told her to email me directly, and she still has not done that. So it's quite disappointing that the responsibilities of the tenants in all of this have been somewhat, I feel, have been somewhat ignored, and just everything is just thrown to the landlord. That's why I've been left with no option but to come here and appeal this decision. My contractor is available various times throughout October, but he gets booked up quickly, and I'm ready to repair the floor that's in the area there, but she's not allowing us to enter into the unit.
Thank you, sir. Mr. Pizzo.
There's animals involved here now, I hear.
Correct. I believe there's 2 cats and a dog. And walkers, I believe. I believe her elderly parents use walkers.
Shelby?
Very simple question.
Sorry.
There's tape on the floor.
Yes.
Did you take it apart and see if there was any damage under the tape?
Under the, like the floors lifting?
Yeah,
Yes.
you did.
Yeah, there was multiple areas that didn't have the tape on them that were lifting as well.
Was there consideration for animals?
No.
Mr. Jackson?
Yeah, through the chair to, I guess, Shelley or Emmanuel. I realize this is a problem if we get it, or when we get it repaired, and I don't know if you guys can answer this. I'm just wondering what the source of this damage is. Like Mr. Ravenick just determined a while ago, these are on outside walls. I'm wondering if this condensation is coming through maybe cracks in the basement wall or something that's letting moisture in. And I know you can't answer that for sure one way or the other, but okay.
Yeah, when I visited the unit, there were no visible cracks on the outside of the exterior. When my contractor visited the unit, there were no visible cracks on the interior or exterior. We did notice some areas of mortar sill that were repaired many months ago that over time have worn out and were replaced. The damaged floor was in a very high volume area. It wasn't throughout the unit. It was only in that central area around where you come into the unit, the kitchen area. Also damaged floor around window areas, which looks like it could be animals scratching or cats. And my contractor told me that he smelled that strong smell of urine when he was around the window areas and the damaged areas of the floor, which if there is something like that happening in the unit, that can damage and take apart floors faster than normal. Yeah.
Mr. DiPaolo?
Through you, Chair, how many units are in the building?
17.
17? 17?
Yes.
And is there any other complaints in the building about mold or other repairs or other safety issues?
No.
So one of 17, and you've owned the building for a while?
Yes, since 2017.
2017.
Well, the bank owns it, but
Well,
that's a different conversation.
I'm curious as to your comment that you're disappointed with the city that they didn't converse. I'm not sure if you're aware, but we've been given a complete file, what I would consider a
Yes.
pretty good file on this. And I went in and kind of looked at this, and when this was first, it appears
If I may
to-
rephrase that, because I think I understand what you're saying, but go ahead, sir. Sorry, my apologies.
Yeah, it appears to me that the tenants initiated their complaint to the city back in April, which the manager of bylaw, Danny, received in April. So your comment that you're disappointed in the city, but because I can see evidence that the manager of the bylaw department sent multiple emails in April and in May, and one of them was to you in May, on May the 23rd, to follow up on the mold. So quite clearly, there was conversation from the city early on to this. So for you to say that you were surprised on July 3rd that this order was issued is kind of bizarre to me, to understand that when you were quite well aware. And there's a neat, what really piques my curiosity is the email specifically of Thursday, April the 24th, that the bylaw department sent to your property manager, suggesting to you folks, because obviously there's a dispute here. You've been a landlord for a long time. You have 17 tenants in that building. There's one particular tenant that, for whatever reason, doesn't really matter, but there's a dispute between you that has now become the problem of this property standards committee, that you guys can't fix this. But he sends this email, and with a suggestion, connect with the tenant to resolve, and bylaw not need be involved. I think you had plenty of opportunity from April to deal with this issue one way or the other. Obviously, there's a problem with your tenant. And all those things that you've have advised that have happened in the pictures, I understand, and that is not necessarily atypical of what happens when you have a landlord-tenant relationship. So I think I'm surprised by your comment is all I would say around that the city didn't converse. I find that from what I can see in the evidence, the city did converse.
Okay.
The city actually tried to let you guys manage it on your own, and I think that's a good thing. What I find though, and maybe I'll now change my comment to when bylaw gets involved, they really seem to sink their teeth in this and get involved. And I just want to make sure that you didn't choose sides on the issue, right? Where when you went in and saw the lady, you had access to her apartment. I just want to make sure you're reporting evidence only that you determined that you saw from a safety point of view that you have to report. And that's why my initial question was to understand, why did you go beyond the mold? And you're telling me that you have to do that. That's part of the legislation. And so I just wanted to make sure that I bring up the notion that the city seemed to be early on this and try to put you two together to solve the matter before we are here today.
If I may respond with...
Sure, go ahead,
Okay.
Emmanuel.
Let me explain the term converse. Yes, there have been many emails, and I acknowledge there have been many emails back and forth, correct. In the conversations that we've had over the phone after we conversed, the term disappointment occurred for me on July the 3rd, because Danny and I spoke. I explained to him the situation was going on. He was happy that the tenant and I were going to be involved directly. That's part of the reason why I told the tenant to email me directly. I told bylaw I'm going to be involved directly, because the management company was not, in my opinion, doing what they were paid to do. So I got involved at that point. We spoke. He understood my position. I understood his position. And I acknowledged what he had to say, and he understood what I had to say. There's emails that indicate we involved the tenant as well. But on July 3rd, the tenant called, and Mr. Vukovic and I spoke about July 4th, about getting everything cleaned up, because I was told, because I wasn't allowed to come into the unit, I was told that there's a small area left. He was aware of that, and the tenant told me that. So the word disappointment should not have been used. Let me explain. It occurred on July the 3rd because after so many conversations and connections and back and forth and attempts to put myself and the tenant together, an order was just issued without contacting me after the manager spoke, like the manager was aware of the date where everything had to be cleaned by. So it just seems it was a little...
I'd like to give the opportunity to Danny or Shelley to
Yeah, no, of
kind
course,
of
of course, of
comment
course.
on what I've observed in terms of the communication, and also to say that it was clear to me that the city didn't really want to get involved in this. You tried, but please comment on that.
Yes, through you, Chair. I want to be clear that the city always remains impartial. I did have a conversation with Block Properties. To the best of my knowledge, they're the property manager at the time. They were more than willing to cooperate. There's email references to the comments. Again, to the best of my knowledge, while conversing with the property manager, there was a professional remediator scheduled to come in. The property manager did state that in the email. However, again, to the best of my knowledge, when the Mr. Junta found out that there's cost associated to this inspection, that inspection was denied. And the property manager at that point walked away and chose not to comment any further.
No.
And as well, I want to add one more comment. During that conversation with Mr. Junta, he did say he's going on vacation with his family and he won't have time to tend to it himself. However, he'll do his best to bring a cleaner in.
If I may,
Sure, go ahead.
there was never anything scheduled. There was a scope of work and a estimate provided in conversation with the industrial hygienist, which they told me what needs to be done. I let the industrial hygienist know what has been done, what needs to be done, and what, if something occurs, for example, it has to be cleaned, and if it reappears, the industrial hygienist said, well, there's still a problem. And that could take weeks, and that could take months before something appears. So nothing was ever scheduled. I did organize everything before we left, and when we returned, I tried to, she was very uncooperative when, on the 2nd, we were trying to get everything lined up before I left, and she denied access. So it's going to be impossible to get into a unit and repair a smaller portion when it was, when access is denied. And again, I want to reiterate, nothing was scheduled. It was, and I'm not sure what the management company said over the phone to Mr. Vukovic, but the scope of work was just explained, and it's just a quote at that time.
Mr. Pizzo.
This is repetitious. This is repetitious. We'll be here till this afternoon. Can you cut it short?
Through you too, Chair, I know you, regardless of what, the management company was your agent. You hired them, they represented you.
Correct.
So whatever they told us was what they told the city. I have to believe that. I just want to make sure, I have one question for bylaw, and then I might be prepared to, think about moving this thing forward. Was there ever, would the tenant have, you never encouraged the tenant not to cooperate. Would the tenant ever have gotten the impression that you encouraged them not to cooperate with the landlord?
Through you, Chair, absolutely not. We always encourage landlords and tenants to work together. However, ultimately, if that relationship falls apart, we do get involved.
Right, thank you.
Mr. Ravenak, did you have something?
Really?
First of all, you've got a tenant. I'm with a nonprofit housing, and I go through this every day, and you know that, every day. Okay, you got a bad tenant. Can we solve this situation with time? Can we do it with, I'm not talking to you, I'm talking to the bylaw people. Can we settle it with time? We did a house in a month. We did a complete $31,000 worth of work. Can we give time to do it? He doesn't do it, we move in. Is that a possibility?
Through you, Chair, yes, that is a possibility.
Because we can't lose people, you know. And I have to ask you, have you any other apartments on below ground?
Yes.
What's wrong? Any problems there?
No.
So my recommendation, I would say, we give you the bylaw says you give them time. It's not done, you move in. Otherwise, we're gonna be here all day.
We spoke about relationship, if a relationship falls apart. If a tenant doesn't allow, sorry, yes. I apologize.
Mr. Ravanack, did you have something to add?
No, did you want to answer
Shelby?
The question was, can we give time? So yes, and when we issue a property standards order, the order was issued the 8th, giving him time till the 29th to complete the work.
29th of what
Okay.
month?
July.
July,
Yep, and then moving forward, is that your question?
I don't wanna lose it. Favorite moment, yes, see it every day.
Yes, that's something we could do.
Mr. Ravanack?
Okay, just a couple of follow-up questions here. First one is to the landlord, following up on what Mr. Jackson said. This apartment is partially below grade.
Correct.
And Mr. Jackson asked if it was possible that there was compromises in the below-grade foundation that could be causing moisture penetrating into the unit, causing the mold. Are you able to visibly see if there is or is not cracks in the below-grade?
Yes, I had my contractor go out, other people multiple times, and there are no cracks below grade that are visible. There's no other reports of anything from any units below grade. There's nothing that would give that sort of inclination.
Okay, so just to be clear, this is just visual, there's no excavation done to determine whether there were cracks or not in that foundation?
No, the area where the alleged mold has shown up, there were 2 windows, and there were mortar issues at those 2 windows, at those 2 areas, and those have been addressed. So those were the only indications where there could be a problem, and those were literally the 2 rooms that had that in there. There were no other rooms, and it was in the corner of the building, so windows on either corner. Other parts of that apartment in the other areas there was no indication of anything, of any moisture.
Okay. So have you actually been in that unit to observe?
I was in that unit one time, yes, and I did not see anything.
You didn't see any mold at all?
In those other rooms, no.
No, but in the rooms that are depicted in the pictures?
I saw some alleged terms of mold, yes, but nothing. I addressed the situation that was there, but I also saw windows open as well when I was there. So the windows being open, as the industrial hygienist says, can contribute to that, especially if during rain events, if those windows are not closed. It's a fine line because you have to have some circulation of air.
Okay, so then going to page 12, the note from the David Morrison, the hygienist, was he in the unit?
He has not been in the unit.
He has not?
No.
Okay, so this is just, how was he making this determination? What information was given to him to make this determination?
This information was given to him through me, from my contractor, from my observations, and from the cleaning contractor that was in there a long time ago. But it was from contractors, and then I relayed that information to him. And I explained what I observed and what I saw, what I fixed, what has been fixed, and I also asked him what the process would be if those were the problems that were addressed. You clean everything up and you wait.
Okay, so you've seen the pictures that were entered through
Yes.
the bylaw office?
Yes.
And it
no,
it does appear to be mold on those baseboard areas in the corners. And
Those were the rooms where the windows were open, yes,
all right.
as well. So it's, but those aren't, as per the tenant. So when I visited the unit, I didn't see that in the baseboard area. So I don't remember if she had a bed there or not. When I spoke with the tenant late June, she informed me that there's only a small area left in the bedroom that remained to be cleaned. And on that point, I would like to, Mr. Vukovic spoke about a relationship falling apart between the landlord and the tenant, and this goes to Mr. DePaul's question as well. who breaks the relationship when you schedule a cleaning and you're doing your due process to go in and the tenant denies the access? That's the part that is very big here, in my opinion.
Okay, Mr. DiPaolo.
Okay, as I I'm prepared to bring forward a motion here, and more questions. It's because I just want to, number one, I want to recognize the fact that I think the city and the bylaw people did their due diligence. They were active. They were trying to get this matter solved without being here. I also want to recognize the landlord that this is one of 17. And so we recognize that he obviously runs a good building and a good property, and it's unfortunate. What we have to understand is the purpose of this hearing is not we're not relationship repair people. No. That's not our job. If you have a problem with your tenant, there's legal matters that you have to take and go over that. That isn't our job. But the purpose of this hearing is really to with the order in front of us today. I think that the order is what it is today, and I'd like to make a motion that we move forward with the order to be remedied the way it is, giving the giving the landlord another 45 days, perhaps, to get it completed, and move forward that way. So I'd like to move that motion that way.
I'll move it, we can talk, I'm sure I know you have some questions. But listen, you
If
guys
you-
did a good job. I see it every day with a nonprofit, I'll tell you that. You didn't do your job, we're gonna give you, I would think we should give you a chance to do your job. If you don't do your job, you're in trouble, buddy.
Absolutely, absolutely. When the tenant denies access, I have proof of it. Yeah. No, I know.
How long would you need? A month? 2 weeks? Listen,
Mr. Vukovic, you gave him 30 days, the first order, which has expired.
Through you, Chair, I would like the committee to consider the original deadline was July 29th. So as of July 29th, the order is legal and binding, giving the bylaw the authority to enter the unit and correct and remediate at the expense of the owner. But we're going to leave it at the discretion of the committee to choose a reasonable date for that to be corrected.
I might say 1931.
I'd like to ask the clerk if that's something that's an option.
Through you, Mr. Chair, it's ultimately the decision of the committee. It's not the decision of bylaw, because we're before the committee, but if bylaw has any information to guide the, any information on how they feel it should be resolved, that's fine.
Mr. Vukovic, it's come back to the committee now, sir.
Yes.
We're
So-
done.
So I have a concern about the cost of the mold inspection. Because if I'm done everything that I'm supposed to do, you're supposed to give it time, and the order states a concerning aspect for me of having to get an inspector in. So if many items were repaired, nothing else everything's cleaned, nothing else shows up, there's no need to have a $3,000 expense for a technician.
With respect, this order was given to you July 3rd or 4th or whatever, the dates are mixed up in my mind. You've not done it.
I wasn't able to. I wasn't allowed to get into the unit.
You weren't allowed to hire a true abatement, mold abatement assessment?
There was nothing scheduled.
Or did
He
you-
gave a quote, and she's not allowing him to come in. So if she's not going to let the cleaning lady come in, which is the first part, how can I have an inspector come in?
Mr. Vukovic,
Through you, Chair, if I'm understanding correctly, Mr. Morrison, let's say he's a qualified remediator, appears to have provided an opinion as to what needs to be done based on a third-party opinion. So he didn't really come and assess the situation himself. Therefore, in my opinion, I don't believe that these comments are warranted, because the expert remediator has the ability to enter and to assess the unit themselves and provide us recommendations. And I'm happy to take that assessment and follow their recommendations.
yeah, no, I agree with you, Mr. Vukovic.
How can the remediator come in if the
Mr. Pizzo.
tenant?
Still on the date, can we do something?
Mover and seconder, make it.
16 units are okay. settle on something.
But I think, Mr. DiPaolo, didn't you, 45-day term?
Okay.
Okay.
I second that motion.
From what date?
Uh,
It's already, the past is the past, but this gives them 45 days to make sure that now that there's an eviction. Now that there's an eviction in progress, look at,
Yeah, that doesn't come.
right, that is not this committee's, this committee is only here to make a decision on the order, on the property standards order that's been issued by the bylaw department.
But the fact remains, that order is done. That order was in July. What were the dates?
Right,
Shelby?
July 3rd,
Oh, so
4th
we're
it was issued.
modifying
Right,
the order.
modifying the order to allow an extension for completion.
Yeah. We're just changing the date.
Correct.
Mr. Chairman,
Mr. Pizzo?
what happens to the bylaw officers if that tenant doesn't let them in the house? You see what I'm saying, guys? What happens if, and we have them in the nonprofit, we have them, they won't even let you in the door. What do you do? What do you do?
Through you, Chair, I am aware on one occasion that the tenant was not able to be present at the time of Mr. Junta's request. I am not aware of continuous denials. That being said, we will work with the tenant. We're going to encourage that they work with the landlord to the best of their ability, as we always do, and I see there is the intention there to do that.
There are multiples.
We have problems. We have, at the nonprofits, they won't let us in the house.
There are multiples.
So can you guys get
And
them?
through you, Mr. Chair, I also had a conversation with Emmanuel, and I did as well offer to go on site with him and the tenant to kind of help
Yes.
this process move forward.
That would be helpful.
There should be no need for that. The tenant has.
No, you're right, but that's,
You're finished, okay? We're talking now.
Kravenik?
I think Mr. DiPaolo's motion to apply the order with the 45-day term on it is great. I like the fact that Shelby has agreed to help coordinate some kind of
peace talks?
cooperation between the landlord, the remediation company, and the tenant, which is great to kind of expedite this thing, so that if there is a bit of an impasse between the landlord and the tenant, that perhaps you can smooth the waters to help access gain to the thing. So if we can get that undertaking from the bylaw department, then I think then we can move forward with the passing the order.
Through you, Mr. Chair, just if I may, I'll write up a motion in accordance with what I've heard so far. I just want to check with bylaw, though. Would you recommend putting 45 days following today's date, or a specific date? Because I can calculate the dates as well and put a
The
specific.
motion's on the floor, 45 days. Let's
There's no
act
motion
on
on the floor, Mr. Chair. There hasn't been a second, so I'm drafting the motion as we speak.
there has been
it.
actually.
Did you
but
make a
we-
motion?
We want you to
Peter
draft
made a
it.
motion, I seconded it. What are you,
But you're
Can I,
gonna- you're
if you'd
gonna
like me to draft the motion and put it on the screen?
Please.
So that everyone's on the same page. Otherwise, I can not do that as well. That's fine.
didn't make a motion.
No, that's a good idea, Mr. DeBono. Put it on the screen.
Do you want an exact date, or is 45 days sufficient?
An exact date is better.
Given what we've heard and the ability of the contractors within the next 30 to 45 days, I think that's acceptable. 45 days from today's date.
Did you make that?
Whatever the calculation is fine.
Yeah, whatever the calculation is, exactly.
I would like the
Yeah, it's just that there's a couple of holidays coming up, right? Thanksgiving, that's why I extended 45 days. So whatever the calculation date is, Mr. DeBono, from 45 days from today, I'm good with that.
Mr. DeBono's gonna write that up, and we'll see it before we
Made
vote.
that motion, so
Before we vote, we'll see it in writing.
you're gonna put it in the board, or?
May I say one more thing? May I say one more item, please?
No.
Okay.
Listen, you got a chance here. I would just take it.
There's the motion, Mr. Chair. I thank you very much for the indulgence of being able to prepare that.
We appreciate your assistance.
Good motion.
Mover and seconder are okay with that?
I'm okay with it.
Mover? Further
Yes.
questions or comments?
I do have a question, if I may.
No.
It's over.
It's before the committee, sir. I don't know why you
I-
don't
well,
understand that.
there's an expense that might not be needed, might not, but that's fine.
You don't know that, neither do we.
Exactly.
It's not cleaned in 45 days, you're in trouble, okay?
All right,
Let's go
that's
home.
enough.
Let's go home.
That's enough. All in favor of the motion? Opposed? Nope. Carried. Thank you.
Mr. Chairman,
Mr. Pizzo.
this is something other matters.
Yep, thank you. Mr. Pizzo.
I'm told that when you get it, you have to have a written notice on from somebody if they got a complaint. I phone you and say, somebody's parking on my street, come and give them a ticket, or do I have to write a form? Okay, so when you went into that building,
I'm going to clarify something. During our phone conversation with the tenant, the floors, mold, and the walls were included in that conversation. However, she was specifically caring about the mold because of her children and her elderly parents. When Shelby visited the property, there was conversations brought forward by the tenant about all of these. Maybe something she forgot to mention. We don't go out of our way to find problems. We deal with whatever comes forward.
Yeah. And with the floors, something like that, it's also, even if I wasn't looking, like, it was there. Yeah, it's something you can't miss, and that's something you couldn't just not address, right? Because a part of our property standards is all floors should be in good repair, so, yeah, yeah.
And if I can say, like, I mean, I read this, like, I completed it. You sent 23 emails.
Yeah.
And it's quite clear, and listen, some of them were on weekends. So, number one, I think you demonstrated a great care to try to put these two people together, and it's just, obviously, it's a relationship, and it's really not for this, but what I'd say is, I think there might be an opportunity to make sure bylaw really sets, tells the tenant, we're neutral in this, like, we're not, you're, like, and I guess sometimes, I think people think, oh, I call bylaw, they're on, like, they're pushing, like, you know what I mean? They think that you're their advocate, and it's not about you choosing sides, it's about,
Yes.
look, I got a problem, it's gotta get fixed, it's what it is, and I think that there's an opportunity maybe to make that clear to the complainant, if I can, but I was thoroughly impressed that you're sending emails on Sundays and Saturdays, I got the times, I saw when it happened, that's the email. I think and listen, but I'm not just kissing up here, the other opportunity is, can't you guys return calls when people call you? Because there was obviously, that was mentioned.
Yeah.
In the emails, right, like, whether it be Jacob, whether it be whatever, like, obviously there was lots of people involved, so,
Yeah.
like, you gotta return a call.
There's a lot of information here that was omitted by Mr. Junta. But that being said, we answer call to the best of our ability, really. All right. So I take those comments. Yeah.
Yeah, it's just,
Yeah.
Maybe we should have a motion to adjourn.
yeah.
You did a good job.
Thank you.
I'm looking for a motion to adjourn so the tape can be stopped. Thank you, Mr. Ravenak. All in favor, thank you. Thank you, clerk.